Miss Christina Zampas, if you could give us your presentation, we'd be grateful. Thank you.
Thank you. Thank you, and congratulations to all of you on this important work you're embarking on and on the transparent and open process with which you're deliberating this very challenging and important issue of abortion law reform. I would like to briefly begin by introducing myself. I'm an international human rights lawyer with almost 20 years' experience working on sexual and reproductive rights issues. I have done consultancy work for UN agencies such as the World Health Organization and the Office of the High Commissioner for Human Rights, and have worked for international NGOs. I am here today in my capacity as legal fellow in the Faculty of Law at the University of Toronto. I began my working career in the U.S. Senate for my senator from New Jersey, and have also worked with parliamentary organizations since then. So I have firsthand experience of your work and its challenges and the very important contribution you make to the realization of human rights here in your country. The scope of my presentation will be primarily focused on human rights standards in relation to abortion and state obligations thereof, which is what this committee has asked me to present. I hope it can be helpful as you proceed in addressing the recommendations of the Citizens' Assembly. I want to first begin by saying that states themselves, including Ireland, create international human rights law, which is based on humankind's common understanding about the inherent dignity and rights of every human being, a notion which is shared across religious and non-religious ethical frameworks alike. Ireland has been an important player in the development of the human rights system, helping create binding treaties and voluntarily ratifying them, nominating and electing members to the UN treaty bodies, which are comprised of independent experts that monitor state compliance with these treaties. Ireland has also sat on the UN Human Rights Council, which is the UN's most important intergovernmental body on human rights. Ireland has time and again, in many ways, respected its human rights obligations. And it has done so not just because these treaties are legally binding under international law, but because they provide guidance on how to address complex and sometimes competing interests in light of the reality of what people are experiencing. Reproductive rights have long been recognized as human rights and are enshrined in international treaty provisions. International human rights bodies have long recognized that while a range of human rights guarantees are undermined when women and girls do not have access to safe abortion services, particularly where abortion is restricted and or criminalized. These rights that are implicated are the right to life, health, the right to privacy, the right to be free from discrimination and from torture and other ill treatment, and the right to be free from gender-based violence. The right to health requires states to take legal and policy measures to prevent unintended pregnancies and unsafe abortions, including to liberalize restrictive abortion laws to guarantee women and girls access to safe abortion services and quality post-abortion care, and to respect the right of women to make autonomous decisions about their sexual and reproductive health. Human rights bodies have considered that such failures to ensure women and girls access to abortion to be forms of discrimination and inequality in the enjoyment of rights. The UN Committee on the Elimination of Discrimination Against Women has confirmed that measures to eliminate discrimination against women and girls are inappropriate if a healthcare system lacks services to prevent, detect, and treat health concerns specific to women and girls, noting that it is discriminatory for a state party to refuse to provide legally for the performance of certain reproductive health services for women. The urgency of the human rights concerns in Ireland is reflected in serious human rights violations amounting to cruel, inhuman, and degrading treatment as found in the Mellett and Wheeling cases. The UN Human Rights Committee held in these two cases that prohibiting and criminalizing abortion in situations of fatal fetal impairment subjected these women to conditions of intense physical and mental suffering, and that no justification can be invoked or extenuating circumstance to excuse such harm. Human rights bodies have also held that a woman's decision to continue or terminate a pregnancy falls within the sphere of private life, which includes bodily integrity, holding that restrictive laws and practices interfere with a woman's decision, violating this right. Human rights bodies have long stated that to comply with human rights obligations, states should decriminalize abortion, liberalize restrictive laws, and remove barriers that hinder access to legal abortion. While they have noted that states must ensure access at a minimum in cases of threat to a woman's life or health, in cases of rape or incest, and in cases of severe or fatal fetal impairment, they have also called on states which allow abortion only on such minimum grounds to liberalize their laws. This is because human rights bodies are recognizing the problem of narrow laws framed around minimum grounds. In one, that they do not guarantee effective access to lawful abortion, and two, that women and adolescent girls seek abortions for various reasons, many of which do not fall under these grounds, and that there are harms and human rights implications in these cases as well, especially for marginalized women. Last year, 4 UN experts issued a joint global statement where they recommended the good practice found in many countries which provide women's access to safe abortion services on request during the first trimester. UN human rights treaty bodies have also recognized this reality by directing states to address abortion in a more general manner without delineating grounds. For example, the Committee on the Rights of the Child recommends that states should ensure access to safe abortion and post-abortion care. It also recently made this recommendation to Ireland. Another expert body, the UN Working Group on Discrimination Against Women, recommends that states should recognize women's right to be free from unwanted pregnancies, noting that many countries where women have the right to abortion on request, supported by affordable and effective family planning measures, have the lowest abortion rates in the world, and that states should allow women to terminate a pregnancy on request during the first trimester or later on minimum grounds. The World Health Organization, too, recognizes that restrictive legal grounds for abortion and other legal, regulatory, and administrative barriers contribute to unsafe abortion because they deter women from seeking care, cause delays in access to services, which may result in a denial of services due to gestational limits on the legal grounds, and create complex and burdensome administrative procedures. The Citizens' Assembly recommendation on access to abortion without restriction as to reason is in line with these human rights and health standards. Although a wide range of laws and policies ultimately determine whether women and girls' equality and right to be free from discrimination are priority for states, trusting women and adolescents to make autonomous decisions about their sexuality and reproduction is central, including to decide whether to carry a pregnancy to term. The UN Committee on Economic, Social, and Cultural Rights has explicitly articulated increased access to abortion as well as other sexual and reproductive health services within states' obligation to respect the right of women to make autonomous decisions about their health. The Committee on the Rights of the Child has called on countries, including Ireland, to ensure that the views of the pregnant girl are always heard and respected in abortion decisions. The Céadaoin Committee has expressed concerns about one country's convoluted abortion law, which makes women dependent on the benevolent interpretation of a rule which nullifies their autonomy, and noted that the state party should review the abortion law and practice with a view to simplifying it and to ensure women's autonomy to choose. Having respect for women and girls' decision-making agency reflected in the law is a key indicator of the degree to which women's equality is respected. The achievement of substantive equality requires states to understand how women and subgroups of women are disadvantaged in practice by laws, policies, and institutions. Laws which do not place women at the center of care and do not respect their decision-making, wherever those laws are, undoubtedly cause harm to all women, but particularly to marginalized women. I have observed in my almost 2 decades of work on this issue that undoubtedly in every country with a restrictive law, the most impacted are vulnerable populations, such as women migrants, women with low economic status, women with disabilities, and adolescents, and Ireland is no exception. The United Nations human rights bodies have time and again, including against Ireland, recognized the discriminatory effects of restrictive and criminal regulation on women's access to lawful abortion on the basis of sex, age, geographical location, and income. The World Health Organization has underlined that restricting legal access to abortion leads to illegal and often unsafe abortions and to social inequities, including because of the burden of travel. It does not result in fewer abortions or in significant increases in birth rates. Women and girls encounter many barriers to abortion. One of them is its criminalization. Human rights bodies have called on states to decriminalize abortion, which means that abortion is no longer regulated by criminal legislation, and it is not a criminal offense. The Children's Rights Committee has urged states, including Ireland, to decriminalize abortion in all circumstances. The Céadaoin Committee has also said that criminalization, as well as denial or delay of safe abortion and post-abortion care, are forms of gender-based violence that may amount to torture or cruel, inhuman, or degrading treatment, and that countries should repeal the criminal legislation. Human rights bodies recognize that the criminalization contributes to stigmatization and creates a chilling effect on access to lawful services. In the Mellet case, the UN Human Rights Committee recognized how the criminalization of abortion degraded and stigmatized Miss Mellet through separating her from the standard way of treating patients and forcing her to travel, and that the shame and stigma associated with the criminalization of abortion had exacerbated her suffering. Human rights bodies have also recognized the chilling effect of criminal law on the exercise of professional judgment in providing women and girls with care and have called on states to alleviate its effects. In ABC versus Ireland, the European Court of Human Rights noted that it considers it evident that the criminal provisions of the 1861 Act would constitute a significant chilling factor for both women and doctors in the medical consultation process, regardless of whether or not prosecutions have in fact been pursued under the Act. Criminal provisions present barriers not only in the context of abortion, but also to other reproductive health services, impacting the quality of care that women receive in pregnancy and childbirth, including in the context of miscarriage. Some national courts understand that the criminal law, as well as other ways of restricting abortion, cause harm and are not a proportionate means to achieve a state's objective to protect prenatal life. For example, European Constitutional Court decisions across Europe have upheld abortion on request laws when faced with challenges due to claims of constitutional protection for prenatal life. While these courts acknowledge that the state has a legitimate interest in protecting prenatal life, the select means of protecting it must be consistent with women's rights. In doing so, these courts have referenced their country's respective obligations under international human rights treaties. Placing women at the center of care does not mean that states should ignore fetal interests. Certainly, the objective of protecting prenatal life is legitimate, but that this can be achieved in ways that are consistent with women's rights and that support women. In addition, the evidence is clear that criminal abortion laws are not effective in meeting the state's objective of protecting prenatal life. They do not affect the overall incidence of abortion, they just make it unsafe and burdensome. This approach is in line with international and European regional human rights norms. No international or European human rights treaty or treaty monitoring body or court has provided that right-to-life treaty provisions apply before birth. This was confirmed by the Council of Europe Commissioner for Human Rights in his report on his visit to Ireland last year. Quote, "The Commissioner stresses that the 8th Amendment of the Irish Constitution departs from the position consistently held by human rights bodies that the right to life, as enshrined in relevant international treaties, does not apply to prenatal life." In addition, in a landmark case against Peru where a sexually assaulted child was not provided with an abortion, in part because of the state measures to protect prenatal life, The UN Committee on the Elimination of Discrimination Against Women found violations of the Convention, confirming that fetal interests cannot trump the human rights of women and girls. Human rights bodies have long referenced achieving reductions in the rate of abortion, not through restrictive abortion laws or recognizing the right to life of the unborn, but through increased access to family planning services and comprehensive sexuality education, to safe motherhood services and prenatal assistance, including to reduce spontaneous miscarriage, and to social and economic protection to ease burdens of having children. Human rights bodies have also recognized that any procedural or other barriers to abortion can impact the ability to access legal services in practice. Human rights require that in cases where abortion procedures may lawfully be performed, all obstacles to obtaining them should be removed. Human rights bodies have recommended states to remove barriers such as mandatory parental consent requirements or financial barriers to abortion services. They have also specified that where health practitioners are allowed under domestic law to refuse to provide abortion services on grounds of conscience, states must adopt a regulatory framework that guarantees access to abortion is not hindered by such practices. They have never mandated a state to recognize conscientious objection in the context of provision of abortion services. They have also raised concerns over judicial or prosecutorial authorization prior to obtaining an abortion on grounds of rape, and to multiple provider authorization requirements, including recommendations to Ireland in relation to the Protection of Life During Pregnancy Act. They have also urged states to eliminate and refrain from adopting mandatory counseling and medically unnecessary waiting periods prior to abortion, and to ensure that healthcare professionals provide medically accurate and non-stigmatizing information on abortion. The World Health Organization has also confirmed these as barriers to abortion that should be removed. Access to information is critical to the realization of all human rights, and in the context of health care, including sexual and reproductive health care, states have an obligation not to censor, withhold, misrepresent, or criminalize information to the public in general, nor to individuals. The European Court of Human Rights, in 2 cases concerning lack of access to lawful abortion, found Poland in violation of the European Convention on Human Rights for lack of proper counseling and information on abortion. Human rights bodies have criticized Ireland's Regulation of Information Act of 1995 as not being human rights compliant. The World Health Organization also emphasizes that the information given to women who are seeking abortion services must be unbiased, non-directive, and provided only on the basis of informed consent. In conclusion, these human rights standards show that narrow exceptions to abortion bans are inadequate to eliminate harms that such laws impose on women and girls. The Protection of Life During Pregnancy Act is an unfortunate testament to how grounds-based laws can hinder women and girls' rights and harm their health. The urgency of the problem is reflected in the recent decisions of the Human Rights Committee against Ireland. Well-functioning abortion laws are guided and directed at protecting women and girls' health and human rights. The human rights framework and its obligations provide a common sense, evidence-based, practical approach to not only permit expanded access to abortion, but also to ensure the delivery and availability of quality abortion services. Combined with guidance from the public health field, including the World Health Organization, human rights enable states to help realize women's equality, regardless of their age, income, or background. Thank you.
Thank you very much, Ms. Zampas.